Welcome back to the morning show here on Arise News. Joining us now from Abuja studio to analyze the Executive Order 6 signed by President Buhari, placing a travel ban on 50 prominent Nigerians, is constitutional lawyer and human rights activist Mike Ozekhome. Mike Ozekhome, and good morning.
Good morning to you, Ruben Abati, and good morning, Nigerians.
Very happy birthday. Congratulations. Today, October 15, is your birthday. I hope you are having fun.
Yeah, you are right. Okay. Well, we celebrated till about 3:30 this morning. I didn't have more than 2 hours sleep. But to God be the glory. I feel 40, yes. Although I'm 61 today.
61? Well, yeah, you really look, you look good for your age.
Yeah.
Yeah, welcome to the morning show. Let's start with this controversy over the travel ban that has been placed on 50 high-profile Nigerians. Now, for the benefit of our viewers, what exactly is an executive order? And how is the executive order, as introduced in Nigeria under this administration, different from the executive order in the United States, from where we seem to have borrowed this new mode of governance?
Well, let me start by saying that from the list I saw, it wasn't 50 Nigerians I now saw, although they mentioned 50, but I saw a list of about 155 Nigerians allegedly banned from traveling. I do not know where the government derived that power from to become the accuser, the prosecutor, the judge, the jury, and even the jailer. We have never seen such abuse of power, such impunity, particularly in a democratic setup. Not even under military dictatorships do we have that. An executive order, what is it? It is simply a mere executive or presidential directive made by the president in a presidential system of government, such as we operate, which we borrowed from America, giving certain policy directions or directives based on laws that are already in existence or based on pronouncement of judgments that are already in existence. An executive order for the avoidance of doubt is not a law. An executive order for the avoidance of doubt is not a judicial pronouncement. But Executive Order number 6 made in July this year by President Muhammadu Buhari has encompassed or amalgamated both judicial pronouncement or judicial imprimatur and the law-making powers of the National Assembly, and amassed them and aggregated them to itself. Never in the history of Nigeria have we had so much powers concentrated into a mere order that is supposed to be merely directing. Now, executive orders originated from America, particularly in the case of Marbury versus Madison, decided in 1803, many years ago, during what you call the Marshall years, because the Chief Justice of America at that time was John Marshall, and it had to do with Marshall, when John Adams was the president. That was the first case in which an executive order having to do with the appointment of Marbury as a justice of peace was struck down, and the court laid down the principle of what you call judicial review of legislative and executive acts. The Supreme Court of America said, listen, although the American Constitution has not specifically provided for this, henceforth, courts of law have the power to review and strike down any executive act or executive order or legislative act that is inconsistent with the provisions of the Constitution. Marbury versus Madison. That case is causa celebre, is celebrated. Now, in Nigeria, we imported that one. Executive Order number 6, made in July this year. It's not the first time presidents are making executive orders. We should not make a mistake about that. And we are going to go to the judgment of Justice Ijeoma Ojukwu later, which a lot of people, including the president himself and the government, has misinterpreted. In 1999, when the new constitution came into being, as soon as Obasanjo took over from General Abdulsalami Abubakar, we had the case of Abia State, Attorney General of Abia State versus Attorney General of the Federation, where the revenue allocation modification order was promulgated or was made by the then president as an executive order. And it was challenged as to whether it or not it was constitutional. And the Supreme Court held that it was constitutional because the order was meant to bring governmental actions into conformity with the new Constitution of 1999 under Section 315 of the 1999 Constitution.
Which gives the president some lawmaking powers.
In May last year, when Mr. President was abroad on a London sick bed, he dutifully, very legally, very constitutionally, and I remember I wrote a piece on him that time that he did very well to have done the right thing, or like what happened during the Yar'Adua time when power was not transmitted, which now had to lead to the doctrine of necessity when the country was on the brink, on the precipice as to who was ruling, whether the infamous cabal introduced by my late good friend Dora Akunyili or the then Vice President Jonathan. I said President Buhari did the right thing. Under Section 143, he transferred powers to his Vice President, Professor Yemi Osinbajo, Senior Advocate of Nigeria, to act. And in May last year, Professor Osinbajo rolled out 3 executive orders as to how to do or how to have ease of doing business in Nigeria, how the CAC must be automated, how a Papa port should work for 24 hours, how customs and excise and immigration should work, matters concerning licenses, waivers, concerning entry visas, and we all applauded him that these are good executive orders. There were 3 he rolled out. So the question is not whether executive orders per se in themselves are lawful and legal. They have always been lawful and legal because they are part and parcel. They are concomitant, and they are corollary to the powers of the president under Section 5.
Well, if that is the case,
execute laws made by the National Assembly.
If that is the case, what then is wrong in this matter, in this instance? Because the federal government, the presidency is saying it is relying on the ruling of Justice Ijeoma Ojukwu and that they have the protection of the law.
Let me now tell you why I said it is a misapplication and a misapprehension of the judgment of Justice Ijeoma Ojukwu. Justice Ijeoma Ojukwu merely said Executive Order number 6 itself is not illegal, but that for the order to be used by the President, the Attorney General of the Federation, acting under Section 174 of the 1999 Constitution, has no option, as suggested by the Executive Order number 6 itself, that he could attach the property of certain Nigerians who were specifically named and others to be named, where there was suspicion that they are proceeds of crime. Of course, you know in law, suspicion, no matter how high, can never amount to guilt. Justice Ijoma, however, said, that before this executive order can come into operation, the Attorney General must ensure that in effectuating or enforcing the order, it must not breach the hallowed doctrine of separation of powers. It must not breach rule of law and must not breach the fundamental rights of Nigerians. I want Nigerians to understand perfectly what Justice Ijoma Ojukwu said, because people have been brandishing it wrongfully, that she did say, oh, it's... Now, executive order itself, order number 6 itself, did not even give the powers to Mr. President to ban any Nigerian from traveling. It has to be understood clearly. It merely said, properties or monies suspected to be process of crime could be attached temporarily. The question is, why did you make executive order number 6? Why did you decide to appropriate the powers of the National Assembly to make laws and the powers of the courts of laws to decide cases?
Well, you recall,
under the doctrine of separation of powers.
You recall that during the last NBA conference, where the president was keynote speaker, he made a point that under his watch, it may be necessary at some point, or when necessary, to suspend the rule of law in the national interest, for purposes of national security. Could this be a demonstration of that affirmation?
Yes, a demonstration of that illegal and unconstitutional affirmation. I think he has very poor legal advisors. Rule of law is a concept that was propounded by Professor A.V. Dicey. And one of the greatest agents of rule of law is equality before the law. And that a law, when made, should apply equally and uniformly to all manners of people. Executive Order number 6 runs foul of this halal doctrine by specifically naming about 155 Nigerians, those who are politically exposed, those who are already undergoing trial, and those who are in the opposition, in the schedule attached to Executive Order number 6. That is what we call a law made ad hominem, a law targeted at certain persons or certain groups of people, which is already a bad law, assuming it were a law. But Executive Order number 6 is not even a law. It's supposed to be a mere directive. So when you now use it as if it were a law, you have misappropriated the lawmaking powers of the National Assembly, which has already promulgated laws in this area that gives you cause for concern. The ICPC Act, the Money Laundering Act, the EFCC Act, the Public Officers Recovery of Properties Act of 1984, which has become an act of parliament now. Section 6, 7, 28, 32, 38 of the EFCC Act have already said properties suspected to be process of crime can be temporarily taken over. And that also occurs with Section, I think, 43 G of the Constitution, that where there is suspicion that property has been involved in a crime, it could be taken temporarily over by the government for the purpose of investigation, just to merely investigate, not to seize it, because you have not yet given the person the right to be heard under Section 36 of the Constitution. Because even Adam and Eve were given right of fair hearing in the Garden of Eden by God himself, the omniscient, omnipotent, and omnibenevolent, who even saw what they were doing, the crime they were committing, yet gave them the opportunity to defend themselves. So Executive Order number 6 runs foul of the rule of law as propounded by Professor A.V. Dicey, runs foul of the doctrine of separation of powers as propounded in 1748. The National Assembly has powers under Section 4, and the judiciary has powers under Section 6 to determine disputes arising between persons between persons and governments, and between governments and governments. So executive order number 6. Yeah.
Chief Ozekhome, yes. Now, you've been mentioning 155 Nigerians as persons who are supposedly on this travel ban list. The newspapers have been reporting 50 names, 50 persons. Now, where did you get your 155 from? Because Garuba Shehu, the presidential spokesperson...
When I Googled...
You Googled? But the presidential spokesman, Garuba Shehu...
When I Googled, I actually saw 156. And I was wondering, if they said 50, where am I seeing 156?
Yeah, but the presidential spokesperson...
Google, ask...
The presidential spokesperson...
Maybe the other ones are still kept... Maybe the other ones are still kept secret, like witches and wizards in a coven. Maybe Google revealed it. Just Google. Ask Google.
But hold on a moment.
How many Nigerians have been banned?
Hold on a moment.
But they will tell you that Google will list out the 156 names to you.
But hold on.
But
Garuba Shehu has come forward to say that, look, there is even no list that has been released. Now, should we be asking the Nigerian government, the presidency, to actually make this list public so that it doesn't become, a secret society document that can be used for any purpose?
Governance should not be opaque. Governance should be transparent and responsible. You cannot govern a people shrouding your acts of governance in secrecy. You say you are banning 50 Nigerians. Apart from some of them that Nigerians themselves have mentioned their names, you have not stated these names clearly. The list I saw, Mr. Abati, was 156 people. And I actually saw specifically, if you look at yesterday's papers, some of them even carried some of these names, you will see that each of the name already has a suit number or charge number attaching to him. These are people already undergoing trial, whom you have not yet proven your case against. The courts have not yet convicted them. Our criminal justice system, for your information, and for the information of our viewers and listeners, Nigeria's criminal justice system is based on the Anglo-Saxon model, which is accusatorial, not inquisitorial, which is the French model. Yeah. By this, we mean that it is the innocence of a person, not his guilt, that is presumed. This has been encapsulated or embodied in section 36 of the Constitution, that a person cannot be convicted until he has been heard in a court of law, afforded his defense, a lawyer of his own choice, before the court can come to conclusion.
His offense
now,
right to him in the
order
language
number 6, what it has done, what it has done is to misappropriate the powers of a court of law to hold people to say, you cannot travel out of Nigeria. Where did they derive that power from? In the past, late Chief Emeka Ojukwu, the present governor of Kaduna State, Nasir El-Rufai, Nuhu Ribadu, Obi Ezekwesili, and Emir Sanusi, at one time or the other, had their passports seized by the government. They went to a court of law, which ordered that the passports be released to them. Now, specifically, when Yar'Adua's attention was drawn specifically to the case of Nuhu Ribadu and Nuhu Ribadu and El-Rufai, who were then abroad, who had run abroad on exile, he ordered that these passports be released to them, because the passport is an adjunct of your right to freedom of movement under Section 41 of the Constitution. Now, if you look at the executive order, even some of the papers reported it yesterday, Justice Innocent Umezulike, former Chief Judge of Enugu State, who is now late, was also banned from traveling. Was the government banning him from having his passport to travel to Arijana Fidarusi, as to go to Paradise? The same government that in December last year had rolled out names of about 10 Nigerians who were already dead to head various government departments. So it is the impunity inherent in it, the arbitrariness, the capriciousness, the whimsicality that they could make such terrible and dangerous mistakes. Let me tell you, Ruben, in the case of Olisa Agbakoba versus
DGSSS.
Director, SSS. Yeah, that time they used to call them SSS. Now they prefer the name DSSS. Fine. The Supreme Court had to interpret Section 38 of the 1979 Constitution, which is the equivalent of Section 41 of the 1999 Constitution. And the Supreme Court relied on the Indian case of Gandhi, which itself had bordered on Articles 21 and 32 of the Indian Constitution, where Gandhi was challenging the forfeiture or the detention of his passport. And the Supreme Court of Nigeria, relying on that case, said, hello, only ownership of a passport is part and parcel of the right to freedom of movement. And that no government, except through a pronouncement of a court of law, can arrogate to itself the prerogative to deny any Nigerian of his passport to travel. So when the government is coming out to ban people from traveling, which is itself was not even allowed or permitted by Order 6 itself, then you are going outside the boundaries, both of your Order 6, you are going outside the boundaries of the doctrine of separation of powers, you are going outside the boundaries of the rule of law.
Chief Ozekhome,
Justice Ijoma made it clear.
Chief Ozekhome, yes. I would like you to comment on another executive order, since we're discussing executive orders. And this is executive order number 8, dealing with voluntary offshore assets regularization scheme. What do you think of that order, executive order number 8, under which government says is trying to prevent money laundering and tax evasion, and that offshore assets must be declared so that those Nigerians who have them can enjoy certain benefits?
Let me tell you, that executive order number 8 again is itself unconstitutional. It flies in the face, because we already have enough laws made by the National Assembly, the EFCC Act, the ICPC Act, the Money Laundering Act, that takes care of all this. What the government is doing is simply fishing in the ocean. They are trying a wide net to see how many opposition fish or how many critical voices fish they can capture. When you are telling Nigerians that their assets offshore abroad, these are Nigerians who are already paying taxes to those governments abroad, you want to put them into double jeopardy by telling them that for assets that they have abroad, to which they are already paying, for which they are already paying taxes, that they should again pay you tax here. Why don't you go and overthrow those governments and take over their sovereignty and suzerainty? That is why I say I do not know who is advising this government, when the government also said that rule of law should give way to national security. No. Rule of law is the father, mother, grandfather, grandmother of national security. Because without rule of law, there can't even be society itself. Rule of law predates society. It started in the Garden of Eden. It was the breach of rule of law by Adam and Eve in eating of the forbidden fruit that God got angry, and he drove them away from the Garden of Eden. So rule of law is the totality of what governs a society and makes us sane and remove us from the Hobbesian state of nature where life was short, nasty, and brutish.
Now, Chief
you
Ozekhome
cannot avoid rule of law. What the government is doing is in blatant violation of rule of law, of the doctrine of separation of powers, And even of the judgment of Justice Ijoma Ojukwu and of Order 6 itself.
Well, Chief Ozekhome is saying, can we subject all of this to the test of the ordinary man, the reasonable ordinary man, that is? I hear a lot of Nigerians saying, look, whatever President Buhari can do to stop these rich men who have stolen Nigerians' money from traveling or seize their assets, he should just go ahead and do it. Is this really of any effect, of any relevance to this matter?
Go to a court of law. Justice Ijoma's judgment said, you must first go to a court of law and get an order of court, even if it is ex parte. Ex parte means behind the other people. When you obtain that order, and the other people are now notified, they cannot go to court to challenge it. You cannot tell somebody's access or tell somebody not to travel. If those ordinary Nigerians we are talking about is because they have not been properly educated or guided. No matter how you want to fight corruption, which you are doing within your government, with sweet-smelling Sasarobia, perfume and cologne, but against opponents and opposition, with insecticides, herbicides, and herbicides, whatever you want to fight, you must do it in accordance with rule of law. You cannot go outside it. You can't take over the lawmaking powers of the National Assembly and the judicial pronouncing powers of the courts of law and say you are fighting corruption. It is because those Nigerians are not properly guided to know that that is dangerous. You know what Martin Yemola said, Ruben Abati. I always like to quote this thing because a lot of Nigerians do not know the danger in what is going on. In 1945, during the Second World War, when the atomic bomb was used to destroy Hiroshima and Nagasaki, Martin Yemola, a German cleric, had watched the German Holocaust against the Jews, where over 5 million Jews were annihilated in gas chambers. They were killed. Now, nobody appeared to be raising a voice that time. You know what Martin Yemola said? He said, first, they came for the Catholics. I did not speak because I was not a Catholic. Then they came for the Jews. I did not speak because I was not a Jew. Then they came for the trade unionists. I did not speak because I was not a trade unionist. Some versions say then they came for the Protestants. I did not speak because I was not a Protestant. But by the time they came for me, it was too late, and there was no one left to speak for me. So when some of those people you are talking about saying, oh, we need to fight corruption, so keep people. One of the members of the Presidential Advisory Committee, who we saved him out. We demonstrated on the streets when Abacha wanted to kill him in Abacha Gulag, when he was put away with General Oladipo Dia. I even read of him one time when he said, oh, you can even line up Nigerians and shoot them. So you can line up your enemies and shoot them without giving them a fair hearing. When it comes to us, when it gets close to us, then you will know. Until I was kidnapped on the 22nd of August, 2013, and released on the 12th of September, I used to hear of kidnapping like a distant echo. It didn't make sense to me. But when I was face to face with my kidnappers, death by installment, fear of fear, for what it means to criminalize a person who has not been convicted in a court of law, that you are trying. You have not yet been able to prove your case against him. But you want to take the shortcut to remove the case from a court of law and tell the judiciary, go to hell. It's another way of intimidating the judiciary and not giving them judicial independence, because you are trying to make the judge feel, well, if the president has already said this man should not have his passport, it means that the man is already guilty. Why don't I better go along that way? Well, all these people undergoing trial have been granted bail. And before the bail was granted, certain conditions or conditionalities were put there. Shorties were gotten. And some of them, when they are sick, they apply to the court. The other lawyers argued, the government lawyers. The court grant them the passport to travel. they come back to come and face their trial.
Let's look
so
at...
what the government has done now is to say to hell with those court rulings that say these people can travel. We are now both the executive and coming, the legislature and the executive. What the government is doing is misappropriating powers like